Lynette Lavender and myself, as cooperating attorneys for the Rhode Island ACLU, will be filing today a class action lawsuit seeking to temporarily enjoin, restrain the enforcement of the Rhode Island sex offender residency prohibition, and ultimately to strike it down as unconstitutional. There are three core arguments in the complaint itself. First, that the statute itself is unconstitutionally vague for several reasons. There's no real definition as to what constitutes a school, and there's no guidance either for law enforcement or the Department of Attorney General to give any indication what is in fact a school, public or private. Secondly, there's no real way of measuring, no effective way, and no defined way of measuring what is in fact 1,000 feet. How are we measuring this distance? From what parameters? The statute is completely vague in that regard. Unless law enforcement and the population as a whole is given real notice as to what a felony is, or any crime for that matter, it is unconstitutionally void and vague and should be struck down. That's the first basis. The second and third basis is essentially a violation of due process. These individuals, all level 3 sex offenders, make up the plaintiffs and ultimately the class, are subjected to essentially banishment from their current residencies, and in many cases homelessness, and that constitutes a deprivation of property and liberty interests that under 14th Amendment case law and Constitution has to be narrowly tailored and strictly construed, and in this case this law is neither. The final basis is that this law constitutes a violation of the ex post facto law. That is, it constitutes a new punishment for individuals that have already been convicted and sentenced for their crimes. Taking a step back from the constitutional violations in this case, this law makes absolutely no sense, and other states, including California, Ohio, and others that have taken a close look at this law, have conclusively found that these laws do anything but increase public safety. Just the opposite. They increase homelessness. In California, a comprehensive statewide study found that homelessness for parolees subject to the law increased 24 times. At the core of registration requirements is the premise that to effectively monitor and supervise those that are considered at risk to reoffend, we should know at a minimum where they're living. What this law has done is essentially uprooted individuals who had, in many cases, long-standing residencies where they were effectively supervised and monitored, and sent them all to Harrington Hall in Cranston, which is the only homeless shelter in the state that can take a level 3 sex offender. So now it's in Nick Mattiello's hands in terms of his district. It makes no sense whatsoever. One of the plaintiffs in particular is living in his residence for the last 28 years, his family residence. He was given 36 hours by the local police department to uproot. He's now living in a motel on Route 146. Again, makes no sense whatsoever. So that's what the lawsuit seeks to do. First, to temporarily enjoin enforcement of the statute, and secondly, to strike it down as unconstitutional.